So my name is Paulo Barroso. I'm the faculty of Boston College Law School, and I'm the director of the Clough Distinguished Lectures in Jurisprudence series. The lecture series is a joint initiative of the Clough Center for the Study of Constitutional Democracy, and I speak here on behalf of Professor Perju in welcoming you, as well as the Law School, and I speak on behalf of Dean Rougeau in welcoming you here today. So the Clough Distinguished Lecture in Jurisprudence has become, since its inception, one of the leading fora in the world to recognize and bring forward profound, cutting-edge thinking about law. It attempts to recognize and host speakers who engage with the perennial questions of thought while facing the problems of our time and the future. This series started with Amartya Sen. The last two speakers were Jürgen Habermas and Roberto Unger, and we are very lucky to have today Alice Ristroph. Alice is a graduate of Harvard College, Harvard Law School, and with a PhD in political theory, also from Harvard, for which we should forgive her. You know why, but I think that Alice is one of the leading thinkers about law. Today, wherever room her mind enters, the lights are turned on. So it's with great pleasure and it's a privilege to us to welcome Alice Ristroph to Boston College Law School.
Well, thank you so much for the invitation to be here and for the privilege of your audience for a short time today. I want to speak to you first about lines. Lines can separate, but they can also connect. When we draw the line, or hold a line, or even when we toe the line, we are speaking of making distinctions, of making separations, or of finding limits and testing them. But when we fall in line, or when we drop someone a line, or when we throw a line, maybe throw a lifeline, I may need someone to do that later, we are finding commonalities. We are making connections rather than separating. So lines can both separate and connect, and I want to talk today about the police, whom you have probably heard characterized. You probably heard the contemporary police force characterized as the thin blue line. Is that line, the thin blue line, is it a line that separates or a line that connects? I am perhaps unduly fascinated with the etymologies of both words and phrases and tried to find out a little more about where the phrase the thin blue line came from. I think it's pretty clear that it's a spin-off of the thin red line, which is a phrase used to describe the British military, a phrase immortalized by Kipling in a poem that both sings the praises and decries the mistreatment of British soldiers, of the thin red line of heroes, as Kipling puts it. In Texas in 1977, a Dallas prosecutor memorably used the phrase the thin blue line in closing arguments at a murder trial. It was a murder trial after the killing of a Dallas police officer, and the prosecutor's invocation of the thin blue line, of the police as the thin blue line, was an effort to suggest the importance and also the vulnerability, hence the thinness, the importance and the vulnerability of police officers as a line that separates, in order to protect. So the suggestion of the prosecutor in that 1977 trial was that police separate peaceful civil order from anarchy and crime and violence. They separate the violent and disorderly from the law-abiding public. The thin blue line, the prosecutor invoked the image, and we know a great deal about that particular closing argument because a decade or so later, with more than a touch of irony, the filmmaker Errol Morris used the phrase, "the thin blue line," as his title for a documentary about that trial. And it's a documentary that explores the claims and I think makes the case that police and prosecutorial misconduct had led to the conviction of an innocent man for the murder of that Dallas police officer. The Thin Blue Line was a documentary released in 1988, and after the release of that documentary, the case was re-examined. That particular defendant, Randall Dale Harris, was in fact eventually exonerated for the killing of the police officer. So the Thin Blue Line, I am not technologically sophisticated and did not bring PowerPoint slides or other pretty things to look at with me today, but if I could conjure one image in your mind to orient us, to start us out in the same place in this discussion, the image that I would have brought there, the image that I'd ask you to think about, is an image of police officers in lines, in formation. There are many of these images in the media in recent months, some in New York after the killings of 2 NYPD officers and the subsequent funerals of those officers. You may have seen the images of officers standing in formation at those funerals, particularly striking and newsworthy images because many of the officers turned their backs when New York's mayor Bill de Blasio spoke, turned their backs in protest at a perceived lack of support from the mayor's office for the NYPD. You may also have seen the images of lines of officers at the Ferguson, Missouri police station, lines of officers standing guard, protecting that police station from the protests that continue to take place in Ferguson. So we think of those lines of New York's finest, Boston's finest, Los Angeles's finest, and even Ferguson's finest. That line, the thin blue line, is it a line that separates or a line that connects? I want to talk today about the thin blue line as a line that connects. And I want to say first, I think it's worth noting quickly, because although this is not going to be the main thrust of my discussion, I think it's a point that we don't emphasize enough. I think it's worth noting quickly that the police connect civility to violence as much as they separate the civil order from violence. The police secure order through threats and often the applications of physical force through the use of violence. That's why we get comparisons of police officers, of the police to the military. That's why the thin red line served as an inspiration for this phrase, the thin blue line. The way that police officers use force are, the ways in which they use force are incredibly important, and I think especially deserving of our attention at this particular moment in American history. But my focus today is on the police in full measure, all of the things that the police do, and not just the use of physical force. When we think about what the police do and what we ask the police to do, I think we will see that the thin blue line is a link rather than a divider in another important sense, setting aside the connection of civil order to the use of force. The thin blue line is a link in the sense that police connect crimes to punishments. They detect and investigate and sometimes even facilitate crimes. Yes, facilitate. I mean, if you think about crimes like drug offenses or prostitution offenses or pornography offenses. All of these kinds of crimes involve participants who are not necessarily ready to rush to the police to report the commission of the crime. And so the enforcement of those kinds of crimes involves a great deal of undercover work, sting operations. So police not only detect and investigate crimes that are happening of their own accord, but police also sometimes facilitate or even orchestrate offenses as part of undercover enforcement efforts. Police identify and arrest suspects, and through all of these activities, police supply prosecutors and courts and eventually prisons with persons to punish. So policing gets us from crime to punishment. And in that sense, it is absolutely central to the operation of the modern criminal law. But it is almost entirely ignored by criminal law theorists, by the philosophy of criminal law. And since you have invited me to talk today on jurisprudence, on philosophical or theoretical questions, I'm going to ask you to puzzle with me about the theory or philosophy of criminal law and the place of policing in that field. In the remainder of my talk, I'd like to do three things. I want to make the case that our normative philosophical considerations of criminal law do in fact neglect enforcement considerations, especially policing considerations. And I might speculate a little bit about why that is. I want also to argue that this is a regrettable oversight and one that leaves us without adequate resources to evaluate and critique the many dimensions of our criminal justice system, including policing itself, but also including some other dimensions of the criminal justice system that might initially seem to be separate issues from questions of policing. And third, and finally, I want to suggest some ways in which our frameworks for evaluating the criminal law, for thinking about punishment, these frameworks, I want to suggest some ways in which they might change if we took a more holistic, comprehensive view of criminal justice, one that followed the line from crime to punishment, one that noticed the role of the police in connecting crime to punishment. So first, is it fair to say that criminal law theory has neglected policing, or that it has overlooked enforcement considerations? You might ask, well, what is the subject of the philosophy of criminal law theory, if not the arc from crime to punishment? It's risky for me to make generalizations about a field that is as expansive and rich and diverse as the philosophy of criminal law. But I think it's fair to say that that field tends to focus on either crimes or punishments as two mostly separate and independent inquiries. So about crime, scholars ponder principles of criminalization. They ask, what should be made criminal? What are the general philosophical principles or normative principles that guide us in deciding when to use the criminal law? And when should we not use it? What are the conditions in which we should, say, relieve a particular person of criminal responsibility? And within this broad heading of crimes, of criminalization, I think we see a great deal of important work about specific offenses. So how should we conceptualize the crime of rape, or of blackmail, or of fraud? There are efforts, very important efforts by philosophers to articulate the conceptual underpinnings of familiar offenses. So that's crimes, and then on punishment, this I think is probably very familiar even to anyone who's been through the first couple of weeks of a criminal law course. About punishment, the usual question is, what is the justification of punishment? Why is punishment justified as a normative matter? Is it a retributive theory, a deterrence theory, some combination, some alternative? What are the moral or the normative justifications for punishment? Nikki Lacey from Oxford, who's one of the many incredible people who has stood up here and delivered this lecture in the past, and frankly, she was one of the names on the list of prior lecturers that made me wonder whether I'd been invited by mistake. Professor Lacey tells us that criminal law theory addresses broad questions, here I want to quote her, broad questions of criminalization and penality, the role of the state in drawing on its power to criminalize, and the justification for state punishment in general or in its particular forms. So crime and punishment. I think that's about right. Criminal law theory considers the enterprise of making things criminal, and it considers the enterprise of imposing punishment for the things that have been defined as criminal. I do wonder, with respect to Professor Lacey's characterization, if she, in the quote that I've just read, if she might overstate the degree to which criminal law theorists give attention to the state. If we look at writing on what should be criminal or on why punishment is justified, I think it's very striking how much state agents are actually absent from both kinds of inquiries. Of course, I think the criminal law theorist, the philosopher of criminal law, always hopes that wise legislatures will listen to his ideas and formulate criminal statutes that heed the principles of criminalization. And I imagine that philosophers of punishment hope that wise sentencers will heed their work and impose punishment in accordance with the philosopher's standards for just punishment. But the agent that's at the center of most philosophical discussions of criminal law is the wrongdoer himself. We look at the wrongdoer and we say, when is someone a wrongdoer? When should he be punished? What is it about him? His desert, his dangerousness? What is it, his likelihood to reoffend? What is it about that wrongdoer that justifies punishment? As I've put it a few times in my own work, criminal law theory tends to operate in the passive voice. When should acts be criminalized? When should the criminal be punished? Why should the criminal be punished? And the agent that does the criminalizing or that imposes the punishment is, I think, too often absent from work in criminal law theory. That's going to become important, I think, to some of the things I want to say about policing a bit later on. So the field of criminal law theory involves scholars who theorize crime in general or who think about specific offenses, and it involves work that theorizes punishment and offers normative justifications for it. With a few exceptions, and I will acknowledge a few exceptions, criminal law theory has had little to say about what transpires in the days or the months or sometimes the years that pass between the commission of an offense and the imposition of punishment. And I want to think about that line between crime and punishment. In order for a crime to be punished, it must be detected, it must be investigated, and it must be prosecuted. Actually, I should rephrase that because I have just slipped into the passive voice myself. So let me say, in order for the state to punish conduct that it has previously criminalized, public agents must detect the wrongdoing. They must investigate it and gather evidence to prove the crime and prosecute the criminal conduct. Those actions by state agents we call the criminal process. And we typically distinguish between the investigative process on one hand and the trial process on the other. In the investigative process, the police are the most important agents of the state, I think. For the trial process, prosecutors and judges become the important state agents. In legal scholarship, and I think in the standard law school curriculum, criminal law, the substance of criminal law, the definitions of crimes, and the criminal process are separate fields of scholarly inquiry, separate fields of education. If you took a substantive criminal law course, you might have learned about mens rea and the definition of homicide or the affirmative defense of insanity or self-defense. But you learn those things in one course, and then in other courses we tend to teach the investigative process, the rules for police officers in gathering evidence. I do know that the law school around the corner, that at Harvard criminal law is taught as one course uniting substance and procedure, but the unfortunate thing about that is it's essentially taught as too many courses crammed into one semester. I mean, that's the experience I had as a student, is that we learned substantive law until the middle of the semester, and then we pivoted and we talked about the police the remaining of this part of the semester, and the two parts didn't connect at all. So there's this conceptual separation between substance and procedure, and I think the field of criminal law theory, where we draw upon conceptual resources and philosophical work, that philosophical orientation focuses on substantive criminal law, both, again, the definitions of crimes and broad principles for what should be defined as a crime and standards for imposing punishment.
that, I think, reflects a substance-procedure dichotomy that's not exclusive to criminal law. It runs through many other areas of law as well. I don't want to overstate my case here for the separation. I do want to acknowledge that I mentioned before, we often separate the criminal process into the investigative process and the trial process. And I do think that the trial process has drawn some attention from philosophers, at least since Jeremy Bentham. And Jeremy Bentham was very much interested in writing about the role of the criminal trial from a philosophical perspective, and that concern is very much evident, say, in the contemporary work of Anthony Duff and the many scholars that he has influenced. Duff has argued, as a philosopher, that the criminal trial serves important moral and political functions. He suggests that, contrary to the common framing of a trial as a quest for truth, Duff suggests that a trial is not exclusively or even primarily a quest for truth, at least as that is normally understood, but instead Duff suggests a trial is a forum to assess responsibility. It's a forum in which a community calls an alleged wrongdoer to account, calls the wrongdoer to answer for allegations of wrongdoing. And importantly, I think in Duff's work, the theory of the trial is integrated into a theory of punishment. After a trial calls the defendant to answer for his wrongdoing, if the defendant fails to provide a satisfactory answer or account of his actions, then punishment is a way of further imposing accountability or calling the defendant to account for his actions. Now, theories of adjudicative procedure or trial procedure like Duff's are not quite ahistorical, but they also tend not to be enmeshed in the specifics of a particular time period or a particular jurisdiction. And in a sense, they don't have to be, because judges and courtrooms and trials are ancient, venerable institutions that have existed with some degree of continuity over a very long time. In fact, you might say the contemporary trials and courts as we know them today, they in some ways are very different from what existed centuries ago, but they do share important dimensions with the courts that, say, drew Jeremy Bentham's attention in the 19th century. And I think even Duff's account of the political functions of a criminal trial, much of that account you could apply, say, to what we know about the trial of Socrates in 399 BC. Wasn't Socrates called to answer for his offenses against the polity, and he was punished only after his answer, what you might have read as Socrates' apology, only after that answer or apology was deemed insufficient, then Socrates was punished. So the theorist who tackles trial procedure is, I think, not necessarily bound by the empirical details of a particular time and place, and that makes trial procedure perhaps a more friendly topic for philosophers who often do aspire to provide conceptual insights or reflections that are not enmeshed in one particular jurisdiction at one particular time. So I speak about Duff's work and about work on trial procedure in part to acknowledge that sometimes the philosophy of criminal law has considered procedural issues, and I think very profitably. But I think also just telling you that a little bit about trial philosophies of the trial might help us figure out why the philosophy of criminal law has not tackled in more depth questions of investigative procedure, questions about the rules that govern policing and investigations rather than the rules that govern what happens in the courtroom. I think it's possible that investigative procedure has received little attention from criminal law theorists because it's not necessarily a topic as well suited to kind of cross-jurisdictional, ahistorical inquiry. in comparison to courts and trials, which have been around for a very long time, police forces are actually relatively recent developments. Early America, colonial America, didn't have police forces as we know them today. And so the specific problem of the police, or the specific role of the police, is a somewhat newer question. I also think that the specific rules governing police activity can and do vary considerably from one place to the next, from one modern legal system to another. In the United States, investigative procedure is largely, though not exclusively, a matter of federal constitutional law. Federal decisions from the Supreme Court sort of, interpret the Fourth and Fifth and Sixth Amendments and set forth minimum standards for police officers, and that field, that body of constitutional doctrine, is itself of relatively recent vintage. Many of the key principles or concepts of constitutional criminal procedure originated in judicial opinions decided in the last half century. So theorizing policing or theorizing the rules for policing, theorizing investigative procedure, it might seem like a project in American constitutional theory, maybe a worthy undertaking, but not quite one that falls within the aspirations of the field of the philosophy of criminal law or criminal law theory. I want to say a few things. First, I think it's not clear how much we should indulge or perpetuate the ahistorical cross-jurisdictional aspirations of criminal law theory. I'm not sure that there exists sort of core fundamental concepts of what a crime is or what punishment is that transcend time and place. But even if they do exist, even if there is some core philosophical idea of what is a crime or what is punishment, I think the implementation of those concepts of crime and punishment in the contemporary world is intrinsically bound up with particular types of state actions, familiar recurring types of state actions, including not only adjudication, but also activities we recognize as policing. And even if the precise regulations for the police vary country to country or place to place, certain core questions about police functions recur across jurisdictions. Across countries, across industrialized democracies, certainly, police investigate crimes and apprehend suspects. To accomplish those goals, they have to have varying degrees of authority to search homes and to ask questions and to eavesdrop and to use deception, and also sometimes to use force. So how much authority police should have to do these things is a central question that criminal law theory should tackle. And I want to say two things about that claim. I think that questions about the appropriate scope of police authority, those are important questions in their own right. I think that you might think about policing as an enterprise and ask about the rules or the ethics of policing or the morality of it, or what boundaries we might want to put on police officers or what we ask them to do. But the point that I really want to emphasize today is that the scope of police authority is an important dimension of the things that are already on the agenda in criminal law philosophy, in the theory of criminal law. That is, it's not just that if you're a criminal law theorist, I'm telling you, add policing to the things that you might write about. I'm saying if you are enmeshed in an investigation of what to criminalize, if you study criminalization, then I think policing is very important to that inquiry. And if you study the justification of punishment, if you are interested in articulating normative or moral defenses of the institution of punishment, then I think policing is central to that inquiry. In other words, policing is not just something that we need to study all by itself, but rather, I think, enforcement considerations, the ways in which the crimes we define are going to be enforced, the ways in which we're going to get from crime to punishment. I think those considerations are central to the questions that the philosophy of criminal law has traditionally tackled. So I want, in short, to resist the substance procedure dichotomy that I've mentioned. And I should also note here, outside of the world of philosophy of theorists, outside of the world of criminal law theory, among criminal law scholars who are enmeshed in doctrine or who are doing empirical work and crunching numbers or who are writing about policy. I think in the rest of criminal law scholarship, there actually is a great deal of skepticism about the substance-procedure divide, and I think a lot of that skepticism comes from the late William Stuntz's influential work. It was a core theme, core argument of Stuntz's work that the procedural restrictions that the Supreme Court had placed on police officers had failed or had little effect because those procedural restrictions were made at a time in which the substantive criminal law kept expanding and expanding. And so even if you have sort of imposed Fourth Amendment limitations on when a police officer could make an arrest or conduct a search, if the background criminal law that police officers were being asked to enforce, if the number of offenses and the scope of those offenses and the definitions of those offenses was getting broader and broader and broader, then efforts to impose strictly procedural constraints on the police would be ineffective. That was a core argument of Stuntz's work, and I think one that has been very influential, again, outside of the field of the philosophy of criminal law. And I just want to suggest that that insight, that the substantive and procedural dimensions of criminal law should be studied in relation to one another, I think that's an insight that should at long last reach the philosophers, the criminal law theorists. So the process of enforcement, the activities of policing need attention within the field of criminal law theory. And I want to suggest, as I said before, that it's not just that we put sort of policing on a list of things to study independently, but that we think about policing when we think about questions of criminalization and when we think about the justification of punishment. So let me begin to spell that out. I think an adequate philosophical account of criminalization must include enforcement considerations. We must think about what powers do we give law enforcement officials when we criminalize a given type of conduct. The questions, if you'll recall, the questions that I identified earlier as the kinds of questions that I identified earlier as typical to criminalization studies ask things such as what is a crime, what should be a crime, what's the best conceptual account of a specific offense such as bribery or theft, what should be treated as criminal. I think all of those are good questions, but I think that we cannot answer them without thinking about the thin blue line. We can't decide how to use the criminal sanction without contemplating how we're going to enforce it, how we're going to detect offenses and investigate them and ultimately punish, identify the people that we're going to punish for them. Whenever we address a perceived social ill through the criminal law, whenever we enact a criminal statute, we empower public actors in important ways. We empower the state to punish, and I think people have noticed that about the substantive criminal law. But when we enact a substantive criminal law, we also empower the state to police, to monitor people, to look for violations of that offense, to detain people, to conduct searches, to make arrests. And I think for many existing minor offenses, for many substantive offenses on the books now, the strongest argument against them, against the criminalization, is not the punishments that those offenses carry, which are often very minor, very trivial. The strongest argument against the criminalization of many minor offenses is the police authority that those offenses produce. So if we are to view the criminal law as a form of state action that should be justifiable in a democratic way, one that the whole community accepts and endorses, then I think that we have to consider the social and political costs of criminalization, and especially the comparative costs of criminalization over other measures, or the costs of criminalization over doing nothing. I want to clarify my use of the term costs here. The criminal law is expensive, but its costs are not simply monetary. I think many of the most relevant costs when we choose to criminalize something, many of the most relevant costs are intangible harms to individual and social interests, the loss of liberty or dignity. Again, not just the loss of liberty or dignity that might come from being punished, but the loss of liberty or dignity that might come from being policed. Separations of families when individuals are in fact punished through, say, incarceration. Opportunity costs for the larger community when large portions of it are incarcerated. There are costs to criminal law. Some of those costs might be incurred as soon as a statute is passed. For example, maybe a statute that criminalizes sodomy inflicts certain expressive harms just by its very existence. But I think most of the costs of criminal law are the costs of enforcement, the costs of policing, adjudication, and punishment. And I do want to acknowledge, I think that theorists of criminalization, again, the scholars who write about what should be criminal, I do want to acknowledge they do sometimes contemplate the costs of enforcement, but they do so in a way that emphasizes punishment and not policing. Doug Husak's work on criminalization, or his recent book, Over-Criminalization, is a good example here. Husak imagines a proposed criminal prohibition of donut consumption, motivated by a state interest in reducing obesity. And again, doing the work of criminal law theory, articulating the principles by which we decide what should be criminal and what shouldn't. Husak suggests that to justify a ban on donut consumption, he argues it's not enough to say that such a law would actually reduce obesity. Maybe it would, even if it would. It's not enough to say that it would actually reduce obesity. It's not enough to say that people have no protected right or special inherent interest in eating donuts. Husak says those things, even if true, are not enough to make the case for a criminal prohibition of donut consumption because persons have a right not to be punished. They may not have a fundamental right to eat donuts, but they have a right not to be punished. And it is not at all clear that the interest in reducing obesity could justify the infringement of that right, the right not to be punished. So, in other words, Husak says we must ask not only whether the conduct in question is conduct we want to eliminate when we're thinking about a criminal statute, we also need to ask whether a criminal prohibition is worth the costs of enforcement. And in Husak's approach, that means a question about whether it's worth the infringement of a right not to be punished. I think all of that is reasonable enough, but I think it's important to notice that punishment is not the only burden imposed by the criminal law. It's not the only thing that a defender of a criminal statute should have to justify. With each new offense, we have to get from crime to punishment. We have to detect the donut eaters and arrest them and prosecute them. And just as persons have interests in not being punished, they have interests which may in some cases be overcome, but the interests are there. They have interests in not being surveilled and not being arrested and not being detained and tried. So part of the problem, I think, with a donut ban, besides the fact that donuts can be really good, part of the problem with a donut ban is the authority that it gives to police officers and to prosecutors. And that authority is problematic in at least two respects. When the authority to arrest or prosecute is actually exercised, it imposes burdens on the individual and on society. And even when the authority to police or investigate or to prosecute is not exercised, the possession of broad authority itself gives police and prosecutors broad discretion that might be troubling in itself. And I should say about all of this, because I'm a great admirer of Doug Husak's work, and I'm using his donut example, he is, I think, cognizant of the concerns that I raise. He is focused on punishment as a cost, but and doesn't address police power, but I think that Husak himself would concede the point that I'm making here. I want to now elaborate a few ways in which questions about police authority intersect with questions about other questions about the scope and content of the substantive criminal law. And here, my discussion is probably more a sketch for further inquiry. I'm going to identify questions more than offer answers. But I do want to suggest a few other ways in which thinking about policing is important when we think about what should be criminal. So most broadly, policing is often quite intrusive. To authorize a criminal statute is to authorize, or to enact a criminal statute is to authorize intrusion. And the intrusions of policing are not subject to the adjudicative constraints that apply to punishment. I think that's important to notice. Notwithstanding, say, the warrant requirement under U.S. law, most police action does not require prior judicial approval. Acting on his or her own judgment alone, a police officer can watch a person or can stop him if the officer believes he has reasonable suspicion, or detain him briefly or not so briefly, or even arrest him and take him into custody if the officer believes he has probable cause. All of these things the officer may do on his own judgment without seeking prior judicial approval. And so all of those familiar components of policing, things officers may do, are intrusive, and I think it's not necessarily surprising that many of those who receive attention from the police resist that attention in some way. Resistance then triggers even greater police authority. A suspect who flees an officer becomes more suspicious. With greater suspicion, officers may take more intrusive measures. A suspect who actually resists arrest, physically resists arrest, becomes a legitimate target of police force, even deadly force. And even if the offense of investigation or arrest was as minor as selling loose cigarettes or jaywalking or eating donuts. So I think here it's worth noting the law of criminal procedure is largely transubstantive, in which means that the same rules for the police officers apply no matter what offense they're investigating, whether they're investigating a minor traffic offense or a murder. And the deaths of Michael Brown and Eric Garner, the deaths that have played an important part in sort of bringing policing to American attention right now, the deaths of those men at the hands of police officers illustrate the consequences of transubstantive procedural rules. And they also illustrate, I think, the ease with which police responses to minor offenses can escalate to a use of deadly force. Now, that principle of transubstantivity, that the officer's basic authority is the same no matter what offense he's investigating, it's been criticized from two perspectives: from those who think that when the officers are investigating terrorism or some very serious offense, they should have fewer constraints, the gloves should come off, and police officers should have more power. And others have said that when the police are investigating very minor offenses, there should be more constraints on the police. I think it is worth inquiring, worth thinking about whether this principle of transubstantivity in criminal procedure, whether it should be abandoned or modified. But without taking a stand on that issue, again, I said I'd leave some questions open. I think that it's clear that our current regime, which criminalizes a vast range of conduct, including very minor offenses, and also preserves as a general matter a principle of transubstantive procedural authority, or investigative authority for the police. I think that is probably the worst of all worlds. I think that this is one of the problems that we're able to identify and begin to think about and perhaps begin to propose solutions to if we place policing within the realm of, within the enterprise of the philosophy of criminal law, the jurisprudence of criminal law. Let me just quickly suggest one other implication and then talk about punishment for a few minutes before we stop to hear questions. A second implication of another implication of enforcement practices is, I think, the definitions of affirmative defenses, and most obviously, I think, claims of entrapment. Entrapment, which I think sort of pretty clearly addresses both questions of the defendant's responsibility and the state's investigative procedures. And an entrapment claim is an argument that I should not be punished because what the police did to investigate this crime crossed some line. It was the police lured me in. They made me commit criminal activity that I wouldn't otherwise have committed. So entrapment is an argument that both addresses the defendant's responsibility, but also the state's investigative procedures. And maybe for that reason, I think it's become something of an orphan in criminal law scholarship, and it's becoming increasingly less relevant as a doctrinal claim that ever wins in real cases. And I think that in the United States, the entrapment defense is so narrowly defined by courts and so rarely successful for defendants that it is increasingly absent from scholarly discourse. But I think if you think about entrapment in a non-technical sense, just sort of the layman's worry about the deliberate facilitation of offenses by the police, it is, as I mentioned at the outset, a very common investigative practice. And whatever the contours of our existing doctrine, our existing positive law, I think normative criminal law theory should devote more attention to the implications for a defendant's criminal responsibility from for investigative practices. In other words, in what ways does the way that the state has chosen to investigate or to police or to enforce a crime, in what ways do those investigative choices implicate decisions about a defendant's criminal responsibility? And that observation, I think, takes us nicely to think about punishment. So if so far I've suggested a few ways in which our thinking about what should be criminal might change if we integrate policing into that conversation, let me just quickly say a few things about punishment, about theories of justified punishment and the ways in which they might look different if we paid more attention to policing. So punishment theory occupies a huge space in the field of the philosophy of criminal law theory. And again, this standard retributive or just deserts arguments are probably familiar to you. There are also deterrence claims. There are theories that try to bring both claims of retribution and deterrence together or propose some alternative to them. But those claims, the work in punishment theory tends to, as I said earlier, first of all be framed in the passive voice. When should the wrongdoer be punished? And it tends to be entirely indifferent to the investigation that brought the wrongdoer before the sentencing authority. I want to suggest, just very briefly here, this is a claim that I've developed it longer, at greater length in an article that'll come out soon. I just want to suggest briefly that compliance with rules for investigative procedure, good policing, I think we should think of it as a condition for legitimate punishment. We don't necessarily frame punishment theory right now as a question about what are the conditions of legitimate punishment. Again, we tend to frame it as when is punishment justified, why is punishment justified, what moral principles explain why punishment is justified. That's an inquiry that sort of takes punishment for granted. Punishment is out there. Is it justified? Why is it justified? I want to suggest instead, let's ask the question, under what conditions may the state impose punishment? Let's focus on the fact that punishment is a choice. It is a choice that requires the actions of various state officials. Under what conditions may the state permissibly, legitimately take those actions? And I think that too much of our conversations about the philosophy of punishment treat guilt, actual guilt, as by itself a sufficient condition for punishment. So if someone is really guilty, then the normative theories of punishment tend to say, well, here's why someone who's really guilty should be punished. He should be punished because he deserves it. He should be punished because he's dangerous. He should be punished because it's important to deter him or to deter other potential wrongdoers. In other words, criminal law theory or punishment theory is not typically framed as a question of conditions for punishment, but if we investigate what are the conditions for punishment under most normative arguments, guilt itself is treated as a necessary and sufficient condition for punishment. I want to say, as a matter of existing law, as a matter of long-standing tradition, and as a matter of sound normative reasoning, guilt is hardly the only condition for punishment. If you think first, just in questions of as a matter of positive law, a defendant, for example, who is actually guilty but who's never prosecuted or convicted, he may not be punished. Think about the target of a lynch mob, for example. Whatever wrongs the target of a lynch mob may in fact have committed, we do not typically view his hanging or mistreatment by the lynch mob as an act of true legitimate punishment. Similarly, a guilty defendant who's actually guilty, but he's violated an invalid law. Maybe he's burnt a flag, and the flag, a ban on flag burning is constitutionally prohibited. It's a guilty defendant, but he's not punishable under our constitutional scheme. The ideal of due process, along with other specific provisions of the U.S. Constitution, imposes a number of conditions on punishment that have little to do with whether the individual in question actually violated an existing statute. An individual who actually violated, say, a statute prohibiting theft, but for whom there's inadequate evidence to prove his guilt beyond a reasonable doubt, that person is not punishable in our system. I want to say that the Fourth and Fifth Amendments, the constraints that our Constitution puts on police officers, also operate as conditions for punishment. So that if the state cannot prove a criminal offense without relying on illegal policing, without relying on illegal searches or seizures or investigative techniques that violate the Constitution, then those defendants are not punishable. The defendants who are in fact guilty, but whose guilt we know only through violations of the constitutional law of investigation. This approach would yield a very different way of thinking about the exclusionary rule, and no doubt a controversial one. I'm happy to talk about it more in questions, but I think the broader claim that we should think about policing, the things the police do, and we should think about good policing as a legal policing, at least, constitutionally permissible policing, as a condition for punishment. I think that reorients our discussions of punishment theory in an important way. So let me close here. Let me conclude by saying, if the task of criminal law theory is to investigate principles of criminalization, of what should be criminal, then the study of policing is an important part of that inquiry. If the task of criminal law theory is to consider the justification or legitimacy of punishment, again, a study of policing is important. We need to think about legal policing as a condition of punishment. And I want to say finally one last word about the thin blue line, about the men and women standing in uniform who I asked you to imagine at the outset. I think police in the United States are under a lot of scrutiny right now, and I think that conversations about policing tend often in one of two rhetorical directions: canonization or demonization. Either the police are saints and heroes, or they are thugs and pigs. I think both of those rhetorical approaches separate the police from the rest of us. And again, as I told you at the beginning, I want to think about lines that connect. I want to think about the connection between the police and the rest of us. And I am troubled by responses to police abuses that frame those abuses as something internal to policing, something that we might address by punishing some police officers or training police officers better, but really by focusing on the police as a whole. I think it's important to remember that police are operating a system that we built, that the voters and citizens of our country built. Police are doing the enforcement that we have asked them to do. And placing policing sort of firmly within the realm of the philosophy of criminal law, I think, enables us to see it. It's true that there are real problems with policing today, that, among other things, too many unarmed black men are being killed or just stopped and searched. But I think these tragedies are occurring on the path from crime to punishment, and that is our road. That is a road that we have all constructed, and I think changing course is probably a bigger responsibility than just the police, the responsibility of the police force itself. So let me stop there. Thank you very much.
So you make a pause at 1:10, because I know many students have classes starting soon, but maybe we have a time for one question before we make that pause for students who need to leave, and then we resume the Q&A. Maybe one question, and then we make a pause. Yes, ma'am.
Thank you so much for being here. I really appreciate it. Just drawing attention to the importance about studying and writing. It's really timely. Appreciate it. So I guess I'm struck both by your discussion about moving the conversation from passive to active, and also just connecting of the lines, and that makes me wonder if it's necessary, and then my question being how so to involve more, so to speak, boots on the ground law enforcement in this dialogue about the theory of criminal law. So my question is twofold. One, how do you see the role of day-to-day police officers in examining our theories of criminal law, and then as a result, how would you encourage legal theorists to engage those officers?
Good, very good question. So I have, in the past couple of weeks, read closely a few times the report on the Ferguson Police Department that was released by the Department of Justice. And the Department of Justice released two important reports. One was about the shooting death of Michael Brown, and concluded that the police officer who shot Michael Brown had not committed an offense for which, a federal civil rights offense for which the Department of Justice would prosecute. The second report, which in many ways is, I think, more tragic, more interesting, more important, is the report about the police department in Ferguson, and sort of a story about why the shooting of Michael Brown would have exploded in the way that it did. And I think, so your question about officers, boots on the ground, makes me think about this report about the Ferguson Police Department. For those of you who are not sort of familiar with the snapshot of the report on the police department, it was covered a bit in the news and summarized in several articles, but the sort of snapshot is that the city of Ferguson, and frankly many other cities in that area and across the country, rely very much on police departments to generate a great deal of revenue for the city. And so there is very painstakingly documented in this report the degree to which the police department in Ferguson stops people for minor offenses, issues summons, issues citations for minor offenses, issues warrants, and every one of these steps, every one of these citations and summonses has fees attached, so that there's an enormous amount of money. It's maybe $50 here and $80 here, but an enormous amount of money that is being pulled in through the police department. And the city of Ferguson is very explicit in telling the police that this is what they are expected to do. So how does that relate to boots on the ground enforcement, what we think about ordinary police officers? I think it's an important reminder that
I don't think police officers are likely, let me put it this way. I think police officers are humans like the rest of us, in the good and bad ways that you might use the adjective human. But I think it's important to remember that the things that they do often reflect what they have been asked to do. So the policing in Ferguson imposes tremendous burdens on the poor African American community. Not only are the police sort of using arrests and citations for minor offenses to generate revenue, but they're disproportionately doing that to the African American population. But that is what they have been asked to do. And I think that in many other places around the country, again, I don't think we should sort of think, I think one of the reasons why the report about the Ferguson Department is so important is that it's not a story of one small community of 21,000 people in Missouri. It is, it's a kind of practice that is reflected in many places around the country. So I think, I don't want to sort of dismiss efforts at improving police training or improving police understanding of constitutional standards. These are the kinds of recommendations for reform that are suggested by the Department of Justice in this report. I don't want to dismiss those efforts because I think they're important, but I do think that the most critical step of reform involves actually not the men and women in the thin blue line who, may sometimes be thugs, but I don't know that there's any greater proportion of thugs among police officers than there is among those of us in this room. So, so I think that the most important changes are not changes in individual officers, but changes in what we ask our police departments to do.